right. Y'all hear me?
Yes.
Perfect. So I had a question on your thoughts with the recent case law in Idaho that extends the Clark ruling. It's called, I think, the state of Idaho versus Bell versus state of Idaho. Have y'all heard of that one?
Hey, yeah, because you emailed us about it, right, Thomas?
Yes.
Yes, I read that case a little bit, and So help us out on that. Give us some more detail on that one.
Yeah. So for those that aren't aware, give a little bit of background. The Clark ruling happened like 3 years ago or so, where it said, hey, in the state of Idaho, a police officer can no longer make an arrest for a misdemeanor that's committed outside of their presence. In the Idaho statute, there was always an exception for like 5 different crimes. For example, like assault, domestic violence stuff, DUIs, etc. Clark ruling took that away. So then back in 2019, we had an Idaho Supreme Court ruling on a case from 2019 that extends the Clark ruling, saying that if an officer, let me get this right, if an officer does not witness the crime, they cannot arrest for it, even if the information was passed on to them from another officer. So the good example they give
the
here,
collective knowledge doctrine, essentially, right?
Yeah, it almost challenges the collective knowledge doctrine. And that's what was in the dissent, saying this is challenging collective knowledge. We should be careful. But essentially now it's saying, like, if I was on a DUI and I called a specific officer over who does DUI investigations, if I leave that scene and that officer determines this person was drunk and they decide to arrest them, they can't. They can only give them a citation because they didn't witness that person drive.
But the other officer did.
Correct.
And that was kind of the case.
He's not there. He can't make that arrest.
That's kind of how that case unfolded, right? There was an off-duty cop saw a guy believed to be intoxicated, got in his car, but then went to work and then relayed that information to an on-duty cop who saw or encountered him at home or something. If that sound about right, I think, kind of the details of that.
Yeah, off-duty officer, actually in our neck of the woods, off-duty officer saw a guy who was obviously intoxicated, get in his car, drive away, reported it to dispatch, also told the officer, his training officer at the time, just called him on the phone. His training officer got dispatched, went to the guy's house, saw the car there, felt it, said it was warm, knocked on the door. A minor kid answered the door and said, hey, yeah, my dad drove the car and we were just at the grocery store. Asked the guy to step outside, ran him through FSTs and arrested him. Now, look, that was a bad arrest in my opinion, but the case made it even worse.
But well, first of all, there's a parenting thing here. If you're a prolific driver of vehicles when you're drunk, you better coach your kids and say, "Daddy's been home all day watching football on the couch," right? So there's point number 1 in parenting. So and I think that case kind of thing that the arresting officer didn't see the DUI crime committed. He was home, but he still established through whatever investigation and made that arrest. So. When you start talking about that the collective knowledge, I don't know. I still feel like we as officers can convey information that we see and can attest to that and tell our partners about it, and they can take action on that.
Yeah.
And so was that the crux of it? Was they were just really saying that we can't, as officers, that horizontal and vertical. I'll talk about that for 2 seconds here. Vertical collective knowledge. Hey, I've got armed and dangerous. I know that I could pat this person down, but I've got stuff going on. I said, hey, John, pat that person down for me. That's vertical collective knowledge. I know John doesn't know at the time, but I say, hey, go do it. Can John go do it? Yeah. Or like there's a horizontal collective knowledge thing we talk about where, people are working on similar cases or some stuff's going on, but there's communication going on with each other. There's similar investigations and we're both kind of, we're talking with each other and that information can be shared. So I think challenging that is significant. I don't know.
Yeah, I think what we're worried about is that, like, for some officers who don't do DUI investigations, if they get called away to go do something else and then another officer completes the investigation, they can't do an arrest. I know a warrantless arrest to be specific, but in our county and jurisdiction, we don't have MDTs. So we're not going to be able to get a warrant without like going down to the courthouse, getting a judge to meet us there. It's not feasible. Yeah.
And it's like that originating officer, doing an officer's report, putting in their accounts and what they saw and making that part of the arrest, or is that being, accounted for in the arrest report?
Yeah. They would do a sup to say, I made the stop and here was the PC for the stop, for example.
Interesting.
But they say like the way it's written is, or the way the prosecuting attorney is telling us now is you have to be on site for the arrest, preferably the person that makes the arrest if you're the one that witnessed it.
So, I mean, that's the solution, right? Is now all of a sudden we don't really have this collective doctrine. Whatever officer's involved in the stop, they observe the driving. If they get a DUI specific officer there, cool. Well, then I'm just going to hang out right there with him and then wait for him to do his investigation. And then I'm going to arrest the guy, right? Because I was the one who observed the misdemeanor being committed in my presence. This is a weird case, right? It's a weird case. It complicates things. There's a whole lot going on. And I'm just wondering, Thomas, right? And Mike, maybe you can weigh in on this. So basically what we have here is we have an off-duty officer, this officer Palace, right? And he calls in, he says, hey, I saw this dude walk out of Albertsons and he looks like he's drunk. I don't see any driving as Officer Palace. All I see is his walking out to the car. Okay. Then the training officer responds and they don't find the vehicle in motion, but they go to the house, vehicle's there. He touches the hood. It's warm. I'm fine with that under Jones because we got exigency, right? So search, but the effervescent nature of the evidence. So I'm good with that as far as the search goes. So I go up and I make contact with my suspect. Kid confirms, yeah, he's drunk and he was driving, or at least he was driving. I make contact with my suspect. I ask him to step outside. We have this conversation. And then he says, yeah, I had 5 drinks earlier and I drove. Right. And I haven't, in the opinion, he actually says, and I haven't drank since I've been home. So whatever level of intoxication I have now, I had when I was just driving. And so now I can't, as this officer, I can't make this warrantless arrest because of the crime did not occur in my presence. So what do I do with this guy? Because I need to take him and I need to have him submit to to breathalyzer, right? Or draw his blood. But I mean,
it's not so much of a problem for us because we have the mobile life lock, and that's admissible in court in the state of Idaho. So I don't have to take them back to the station to do anything. In that situation, I would have gathered breath myself and then just wrote him a citation.
Okay. But I mean, so think about so Thomas, he says no. He says, I'm not going to walk over to your car and blow into your machine.
I think at that point, to be honest, that would be over my head. I would call the on-call prosecutor and just see if we need to get a blood warrant at that point, because that's kind of like a refusal, right? Like, what am I going to do next? I'd probably get a blood warrant from a judge.
Yeah.
So I'd have to have an officer sit on the house with the dude while we go get this process going.
Right.
Matthew's got more information on that.
I mean, mostly what this case truly affects too is like FTOs and trainees, right? Because getting them on scene to do the investigation for a DUI that did not happen in their presence, that's where it's really affecting us. But
Training
at the end
aspect of it,
what was that?
the training aspect of it, like, hey, I haven't done DUI yet. Hey,
Yep.
call your training over here to do. Okay.
Yeah, trainees, and then actually going through the arrest. But on top of that, I mean, this case was it doesn't go against the Fourth Amendment. It goes against the Idaho Constitution. That's what this case was filed on, which was the same thing as the Clark ruling. So, because Idaho's, it's, I would say, more strict than the Fourth Amendment by far. So this case ruling is really against the Idaho Constitution. I mean, at the end of the day, right, the Clark ruling, if a misdemeanor was not committed in your presence, you cannot arrest for it. You can still do a citizen's arrest, but you cannot be the one doing the arrest. So with this, the off-duty officer that was not there at the scene and did not arrest the suspect, right? This just created a huge crap show for this ruling. So, I mean, pretty much it's just, if for DUIs, if it was committed in your presence, you have to be the one to pretty much say you're under arrest, right? So it's not against the Fourth Amendment, just the Idaho Constitution. So it's not going to go, I don't believe it's going to go to the Supreme Court because it stops at the appellate level with the Constitution.
All right. What about domestic violence in Idaho? That's usually a misdemeanor not committed in your presence. You guys have
Correct.
You have to have arrest power written into statute for that?
Nope. We have to, depending on your agency, we have to, not depending, you have to get an arrest warrant in order to effectuate that arrest. But depending on your agency, and you can get it pretty quickly. But, with smaller agencies in Idaho, just like the other guy said, right, they don't have MDCs. They have to actually go down to the court or wake up a judge and go to their house to get that arrest warrant signed. So, I mean,
to make a misdemeanor battery domestic violence arrest.
Yes.
Yeah.
Yep. Not do it unless the victim wants to do a citizen's arrest.
Well, that's not good for anybody.
Right. And absolutely. So, yeah, it's, the Clark ruling was very tough. The Bell ruling's even more tough. But, at the end of the day, it is what it is. And
that leads to really not questionable, but it leads to us trying to get around the law to make an arrest sometimes, especially in smaller agencies.
Thomas, what are you saying? You're saying cops trying to work around the law? What are you saying here?
No, let me explain, right? Just as lawyers use the law and the words of the law, cops do the same thing, right? I think we're
creative as hell, aren't
we? When it talks about in the case of domestic violence in Idaho, it can be a felony, right? Depending on the level that the person was beat, traumatic injury. Traumatic injury can be internal injuries that you can't see. So you could charge him with a felony if you could articulate somehow that it was traumatic.
Creativity, right? There you go. Articulation.
Yeah. But I get nervous doing stuff like that, though. It's not a good practice because you could end up with more case law,
Well, yeah, I mean, you've got to be genuine. You've got to truly believe that, you got to make sure.
Of course. Yeah.
Sounds to me like you guys just need to decide who's going to be the agreed upon citizen tonight. You take off your vest, you take off your gun, and you come in and effect that citizen arrest. Understand, I'm not in my role of a police officer right now. I don't know. Asinine.
Well, thank you all. Hopefully that helps a little bit, Thomas. And thank you, Matthew, again.
Thanks.